Thank you for joining us here at Real Estate After Death. I'm here with my trusted lawyer, and we are going to be talking about today, what is a will? But before we do that, the most important thing I want to share with you is who she is. So, Raluca, can you please tell us what you do? Who are you? And then we'll get into the question.
Hi, Chaunyce. Thank you for having me. My name is Raluca Stoica. I'm a wills and estates lawyer and real estate lawyer in the GTA.
Incredible. And can you share with us what's a will?
A will is a legal document in which the testator, so the person who has their will done, appoints an executor, appoints a guardian for their children, and names beneficiaries for their assets.
Incredible. Slightly off topic, but you touched on it. What if you don't have an executor for your children or guardian? Did you say guardian? What happens?
Both.
Okay, can we talk about that?
Yes, absolutely. So if you don't have an executor or a guardian, most chances are that if you have a will, you have an executor. Sometimes your executor passes away and then you don't have an executor, but that's more of a one-off scenario. Let's say you pass away without a will, so there's no executor to your estate. Somebody needs to step up. So the executor is the person that administers your estate, that literally takes over a hold of all of your assets and distributes them, or rather liquidates them, pays your debts. Yeah.
Sorry, I'll make this easier for you. Hypothetically speaking, what if you're a married individual, you and your spouse create a will, and then 3-4 years down the line, you guys have a kid? One of the individuals dies without updating the will. What happens with the kids? Or like, I don't know, the other spouse isn't there, you're a single individual, you had a will, you never put the child in the will to have an executor or anything like that. What would happen?
So if that means that there's no guardian appointed, it's fine if one of the spouses pass, one of the parents, the children's parents pass away, and the other parent is left behind. And if there's no issues there and there's a good relationship, then that parent would become the guardian. But however, the issue is, or the risk is, where both parents pass away. Let's say in a common accident, and then there's nobody, for no guardian appointed in the will for the child, then somebody needs to step up and take the child in and then formally apply for custody in court. The benefit of having a guardian appointed in the will is that there's an interim period, 90-day period, where somebody is already stepping in because the testator thought about this person who would be the best person to step in for their child. So the guardian steps in for 90 days and takes care of the child while maybe probate is taken care of and the initial arrangements, funeral arrangements are taken care of. And then that person or somebody else after 90 days would still need to apply to court for custody. So it's not a permanent appointment, but it's an interim appointment when there's a lot of other things happening and somebody can right away step in and take care of the child.
Got it. It's like that person with a will, that person would have already known they're the person, they'll step up right away. Without, there's a few more steps that have to take place.
Yeah, a lot, like people, they may, nobody, if maybe people are discussing, or should I step, should you, should, so there's there's confusion. And of course there's also confusion on for the child, because the child is going through a lot of emotional upheavals at that time. So having somebody there who's already thought of, who the testator already thought about, is a really great asset.
Absolutely. Well, thank you for sharing your expertise with us. If anyone has any questions, please always reach out to Raluca. For now, always like, comment, and share. Thank you.